2 years. Award is not passed within 2 years, then it lapses.
First, further, if such award is not passed within 2 years, then section 11A becomes invocable.
So therefore, our humble submission, my lords, is that the Honorable Supreme Court has not said, contrary to the ruling of Indore Development, where their lordship's constitution bench has categorically held that once possession is taken under the scheme of the Land Acquisition Act 1894, if it is a regular possession under section 16, moment possession is taken, title vests. If it is a possession under section 17, subclause 3A, even then, if possession is taken, albeit with irregularities, title vests. The only recourse of the land loser is to get penal interest between sections 31 and 34 of the Act. Because under section 17(3)(a), there is no mandate that just because you have taken possession illegally, the acquisition lapses. This is the ruling of Indore Development.
No, suppose that will be an extreme proposition, brother.
My lords, that is the proposition in the Indore. I will take my lords through the paragraphs. Because their lordships, the earlier land acquisition law was very clear. The moment possession is taken, right or wrong, title will vest in the state. Now the land loser,
Exclude challenge. Suppose if the, what
Yes,
is the meant by constitutional
because there is
guarantee?
no concept of divesting. There is no concept of divesting.
Divesting, all right. Suppose if the acquisition is set aside on the ground of marked illegality in the acquisition process, still will not be divestation.
My humble submission, my lords, my understanding is, if I read the relevant,
English law that can be.
yes, in Indore Development,
English law.
yes,
King is the owner of all private properties. There is nothing like private property.
yes, yes.
It's only fee simple.
Yeah. Just a few paragraphs of Indore.
Sangilla.
Just a few paragraphs of Indore I will rely on, just to buttress this point.
Yes.
In fact, learned senior counsel, Mr. Raghavan had argued it. I'll just point out those paragraphs, just to refresh my notes.
Just for a moment,
Yes.
you are a professor. I have great respect for you.
No.
Really. Suppose, let us take the consequences of your argument.
Yes.
Once a possession is rightly or wrongly taken,
By
the
the state.
state becomes the owner of the property.
Correct.
Then only remedy availing to the citizen is to go for recompensate, and not the property at all.
He cannot get the property back because it
That
is,
amounts to
it is eminent domain. My lords, it is the right of the state.
the eminent domain, not on English soil, on Indian soil, subject to 300 capital A, subject to provisions of Land Acquisition Act, law relating to land acquisition enacted in various legislation. It's not that broad as it would have had when the barons in England used to exercise power. That is not our eminent domain. Eminent domain, historically, yes, you are right.
Yes.
But once it is shown by the citizen, the acquisition process is marred by marked illegalities.
Yes.
Though you have taken possession of the property,
Yes.
he is entitled to say acquisition should be invalidated and property should be restored to me. That appears to be broad view of V.G. Ramachandran.
Yes. Yes.
Many
My lords, I
judgments.
bow down, my lords.
1 second.
Yes.
No, I have not completed. Now, accepting your contention, once possession of the land is taken, in no circumstance it can be, state can be divested of that.
Yes.
Any proposition, any law to that effect?
My lord, Indore.
And the citizen can go only for recompensate.
My lord, the Indore Development Constitution Bench ruling of the Honorable Supreme Court.
ಯಾವುದು?
Either Indore Development. Kindly see
Yes.
in my list of authorities, first batch.
ಆ proposition ತೋರ್ಸಿ. Appears to be
Yes.
extreme ಅಂತ ಅನಿಸ್ತದೆ. I may be wrong also. Perhaps if Holla, Mr. Holla, do you subscribe to
No,
that?
my lord. That point-
Independent of this case? Independent of this case?
Independent, my lord. Ultimately, my lord, we have to tell your lordships
Legality
correct
only.
proposition of law before your lordships. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು.
My lords, I don't know if my understanding is mistaken, but
No, no,
my humble
you-
reading of Indore Development is this.
Law always shows its face in mask. This is
Yes.
what Jeremy Bentham used to say. At times, it's my
But my
experience also.
right or wrong
Let us see.
interpretation of Indore is this.
Let us see, let us.
Para 116 of Indore, my lords, at page.
In fact, Apex Court in Abdul Hamid versus HMT versus Abdul Hamid said, you have accomplished acquisition proceedings contrary to law by involving a middleman agent.
Yes, my lords.
Therefore,
Yes.
you give back land.
Yes,
Land was taken by the state.
yes, my lords.
It was distributed to the societies.
Yes,
Society in turn formed layouts,
yes.
gave the sites to the aspirants. Supreme Court said, give back that land to the state.
No,
to
not
the
only that.
landowners.
Supreme Court also said, give back the compensation which the owners received.
That also.
ಅದನ್ನ ನಾನು ಹೇಳ್ಬೇಕು, ಆಮೇಲೆ ಹೇಳ್ತೀನಿ ನಾನು.
Anyway,
ಜಡ್ಜ್ಮೆಂಟ್
My lords, with my limited knowledge, I only rely on
ಯಾವ್ದು paragraph?
Indore, para 116.
Page number?
Page. I'm sorry, the page number is missing.
ಅಲ್ಲ, ನಿಮ್ದು ರನ್ನಿಂಗ್ ಪೇಜ್ ಇದೆ ಏನೋ?
Running page, you just tell. Page number. Page 130, 137.
137. You are right.
May I read, my lords?
ಅಲ್ಲ, ವಸಂತಿ.
It is apparent from a plain reading.
ವಸಂತಿ, 137 is ವಸಂತಿ. ಹೌದಾ? ಅಲ್ಲ.
By you ಕೊಟ್ಟಿರೋ compilation.
Now go to 116, your lordship. This.
Internal page?
My lord, there is some mistake in pagination. Kindly provide the, I will show your lordships the copy.
ಅದು ನಿಮ್ಮ ಇದ್ರದ್ದಾ?
Yeah,
ನಿಮ್ದಾ?
ಇಲ್ಲ, ಈ ಹಳೇದು. ಅದು
ಅದೇ
ನಾನೇ
ಕೈಯಲ್ಲಿ ಹಿಡ್ಕೊಂಡೇನಿ, ಸಿಕ್ಕಿದೆ.
para 116, your lordships.
116.
It is apparent, yes.
Two 42, internal page.
Internal page 242.
It is apparent.
It
From
is
a clear
apparent
reading
from
of
section
16.
16 that the land vests in the government absolutely when possession is taken after the award is passed. Clearly, there can be lapse of proceedings under 1894 Act only when possession is not taken. The provisions in section 11A of the 1894 Act states that the collector shall make an award within a period of 2 years from the date of the publication of the declaration under section 6. And if no award is made within 2 years, the entire proceedings for acquisition of the land shall lapse. The period of 2 years excludes any period during which interim order granted by the court was in operation. Once an award is made and possession is taken, by virtue of section 16, land vests absolutely in the state, free from all commitment.
No, you are reading something not there. Once possession is taken under section 16 of the 1894 Act,
Yes,
ನೀವು ಬೈ ವರ್ಚು ಅಂತ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಿ.
ಅಲ್ಲ ಇಲ್ಲ ಅದೇ ತರ ಇದೆ. By virtue of section 16, land vests ಅಂತ ಇದೆ ಇಲ್ಲಿ. I don't know if there is any change in the wording there.
Paragraph.
Paragraph 116.
But award is taking possession as provided in section 16. Correct?
Yes, my lord.
Once possession is taken under section 16 of the 1894 Act, the owner of the land loses title to it and the government becomes the absolute owner of the land.
ಇಲ್ಲ ಇದು ಬೇರೆ ಇದೆ.
ಹೌದು.
I may just give my copy only. I will just refer to my copy only.
Paraphrasing ಮಾಡ್ತಾರ ಅವ್ರ ರಿಪೋರ್ಟ್ ಇದು ಪ್ರಾಬ್ಲಮ್ ಇದೆ ನಮ್ಮ.
Mine is the same as what the court is reading.
ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟಾ?
Indore development, ತಾನೆ? Same as what the court.
Same.
My lord, I may give this one so that it is, seems to be a different version. I'm sorry.
ಇಲ್ಲ ಪಾಪ ಇಲ್ಲಿ ಹಂಗಿದ್ರೆ ನೀವೇ ಸಾರಿ ಹೇಳ್ಬೇಕು. ಇಲ್ಲಿ ಹಂಗಿದ್ರೆ ಪಾಪ ನೀವು ಓದ್ತೀರಿ ನಾವು.
Yeah, even the highlighted portion, I would just.
No, this is different from what you are reading. By virtue ಅಂತ ಇಲ್ಲಿದೆ.
Once an award is made, possession is taken by virtue of section 16. Land was absolutely in state, free from all enemy. Vesting of land is correct ಇದೆ ಇದು. ನಾವು
Correct.
ಓದಂಗಿದೆ ಇದು.
Then below that also, my lords will see the next paragraph. Their lordships
117.
discuss what is to happen in case possession is taken without complying with the mandate of law.
Payment of compensation of 1898 is provided for by section 31, which is to be after passing of the award under section 11. The exception is in case of urgency 70 E, where it has no tender for taking possession. Once an award has been passed, the collector is bound to tender the payment of compensation to the persons interested as found in the award and shall pay it to them unless prevented by contingencies mentioned in 2 of 31. Section 31(3) contains a non-obstante clause which authorizes the collector with the sanction of the government in the instant interest of the majority with the grant of the mission of land revenue. On the 117.
Yes, 117, then kindly come to 118, my lords. What is to happen if the compensation is not paid? It has to be deposited in the court.
Pay such amount to a person interested inside, unless the collector is prevented from sowing inside. Budget of court in case of state is prevented from making in the event of.
Then,
ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೆ. ಈಗ ರಿಪ್ಲೈ ಇನ್ನೊಂದು ಏನೋ ತಿರ್ಗಿ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ರೆ ಇಲ್ಲ,
Section 34 deals with the section. ಅದೇ ಇಲ್ಲಿ ಹಂಗಿಲ್ಲ ನೀವು ಹೇಳಿದಂಗೆ.
Like, kindly come to the last para, my lords, para 120. There is some confusion. Para 120, your lordships get.
120.
Bottom line,
It is
what
apparent
follows is that
89.
in the event of not fulfilling the obligation to pay or to deposit under sections 31(1) and 31(2), the 1894 Act did not provide for lapse of land acquisition proceedings.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ?
This para 120, I don't know why there is some.
It is apparent from 1894 Act ಅಂತ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದಾ?
Yes, my lords, there, yes. In that,
That the
after
payment
the
of
fifth line,
compensation is dealt with for so and so, so and so. So and so, taking position under section 30, that is section 30. Position can be taken before tendering the amount except in case of urgency, and deposit of amount has to follow in the case of collector prevented from taking.
what follows
What
is that.
Those is that in the event of not fulfilling the obligation to pay or to deposit under 31 to 31, the 1890 did not provide for lapse of land acquisition and only increase interest fall
With payment.
ಅದನ್ನ ಕರೆಕ್ಟ್ ಅಲ್ಲ ನಾನ್ ಪೇಮೆಂಟಿಗೆ ಅಷ್ಟೇ.
Yes. And therefore there is no lapse. Then, my lords, kindly see para 134 to 135. Again, repeating of the same thing. I will not trouble my lords. Then para 136 to 140, the same discussions. I will just give these paragraph numbers so that I don't trouble my lords, because in the end, their lordships have summarized it.
ಎಲ್ಲದು?
In the end, kindly come to para 366(4), the operative portion of the entire judgment.
366. What?
Last part.
The expression paid.
Paid. Then, my lords, kindly come to the sixth line. In case the obligation under section 31 of the Land Acquisition Act has not been fulfilled, interest under section 34 of the said act can be granted. Non-deposit of compensation in court does not result in the lapse of acquisition proceedings. In case of non-deposit with respect to the majority of holdings for 5 years or more, compensation under the 2013 Act has to be paid to the landowners as on the date of the notification for land acquisition under section 4 of the 1894 Act. Therefore, my lords, my limited understanding of this judgment is that these paragraphs which I have called out, no doubt as learned.
Where in other, what you say is,
Yes,
if 80% of the amount is not paid, on that ground, acquisition cannot be voided. He can seek interest on that.
yes.
Section itself would have said that way.
That is what the section has said. My lords, kindly see section 31 to 34, which is what the section says. Because section 17(3)(a) does not say if you don't pay, it will lapse. In section 11(a), there is lapse. In section 6(1), there is lapse, but not in section 17(3)(a).
Suppose if it is a precondition,
Even so, the statute does not mandate it. Statute does not mandate.
then a penal counsel submits that non-payment of 80% of the compensation when land is taken under section 4 read with 17(3) kept 3(a), comma, would not result into lapsing of the proceedings, but it may entitle the landowner to additional interest.
And even at your lordships would note 15%, which is a penal sum under section 34.
Interest.
Or from the second
Maybe-
year onwards, it is
Maybe at the
15%
rate of 15% by way of penal interest.
interest.
First, in support of this, he reads out paragraph 366.4 of Indore Development Authority.
And my humble submission, my lords, by no stretch of the imagination, could it be said that this is arbiter? Why? Because no doubt their lordships were considering all this in the context of section
He
24(2).
He hastens to add that this 366.4 is the law declared under Article 141 of the Constitution. And by no stretch of imagination, it is an arbiter.
Arbiter.
All right. How this is treated
Yes,
by the
in-
subsequent
yes.
judgment.
Kindly come now to Delhi ATEC.
ನಾನು ತೋರಿಸ್ತೀನಿ.
ಹ?
ನಾನು ಆಮೇಲೆ ತೋರಿಸ್ತೀನಿ.
ಅದೇ. ನೀವು ತೋರಿಸಿರಿ ಈಗ already.
ನಾನು ತೋರಿಸಿದ್ದೆ. ತಿರ್ಗಾ ಅವ್ರಿಗೆ ಅದು ಆಮೇಲೆ ಮಾಡಿದ್ರಿ. ತಿರ್ಗಾ
He wants to say something.
ಅಲ್ಲ ಇರ್ಲಿ. No, I
ಅಲ್ಲ,
could
just
not
a
Not
few
fit that
minutes,
I have
then
not
I will
heard,
I understand.
ಅದು.
ಯಾಕಂದ್ರೆ ಏನಂದ್ರೆ ಎಂಡ್ ಆಫ್ ದ ಡೇ ದುಡ್ಡು ಕೊಟ್ಟಿರೋರು ನಾವು. This is the bottom line. ಇಲ್ಲಿ 9 ಕೋಟಿ
ಅವ್ರು ಲ್ಯಾಂಡ್ ಕೊಡೋರು ನಾವು ಅಂತ ಅವ್ರು ಉತ್ತರ ಕೊಡ್ತಾರೆ. ಹಂಗೆ ಅದು ಎಂಡ್ಲೆಸ್ ಆಗ್ತದೆ.
ಆಯ್ತು.
ಅದು ದುಡ್ಡು ನಿಮ್ಗೆ ಯಾರು ಕೊಡು ಅಂದ್ರು ನಮ್ ಲ್ಯಾಂಡ್ ತಗೊಳ್ಳೇಬಾಡ್ರಿ ಅಂದ್ರ ಅವ್ರು.
ಆಯ್ತು.
ನಮ್ ತಗೊಂಡು ನೀವು ಹಿಂಗ್ ಮಾಡಿರಿ ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್.
Kindly come to Delhi ATEC, page 13,
1(3) of your
first compilation. There, my lords, kindly see the opening two paragraphs, how this case arose. Your lordships would kindly see, there was a divergence of opinion in the Honorable Supreme Court, whether if land is taken without complying with the requirement of section 17(3)(a),
A, what would happen?
what would happen? And there was a divergence of opinion.
Correct.
Then kindly see para 4 at the bottom. Hence, respondent number 1 being the appropriate government issued the notification dated so and so invoking the
ಎಲ್ಲಿ
special
ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು?
para 4, my lords,
Of page,
page 13,
ನಿಮ್ಮ compilation
non-compilation.
13 ಅಲ್ಲಿ ಬೇರೆ judgment ಇದೆ.
Delhi airtech, my lords.
ಈ state ಕೊಟ್ಟಿದ್ದೀರಿ.
Because the state also had given one compilation. We give up this is our company.
ಅಲ್ಲಿ ನಿಮ್ಮ ಅವ್ರಿಗೆ
It's ತಗೊಳ್ಳಿ sir.
ಅದಾ ಅದರ
And-
ಇದೆ ಅದಿದೆ. 1 second ಅದಿದೆ.
Okay, okay.
1-3 ನಾ?
Yes, ma'am.
You are right.
Yes, ma'am. Para
Delhi
4.
airtech. Okay.
Now kindly come to
ನಿಮ್ ತೊಳಿ.
the last 3 lines, my lord.
Page number.
Page 13. Page
Three.
13, yes.
Ah,
Last 3 lines. Hence, respondent number 1 being the appropriate government issued the notification dated so and so invoking the special power due to urgency. The notification was therefore issued under section 4(1) read with section 17(1). So this was a case where urgency clause was involved.
correct.
Then at para 5, fifth line, however, it is not disputed that possession was nevertheless taken on so and so. But the grievance raised by the appellant is that neither the initial requirement of tendering and paying 80% under so and so, nor was the requirement of section 11A of the act to pass the award within 2 years from the date of declaration was complied. So this was the question in para 5, twin requirements,
Payment plus timeline.
timeline. So the question really was, if the acquiring authority has not complied with section 17(3)(a), are they not bound by section 11A? And can they take their own sweet time to acquire the property?
1 second.
Yes,
Lapsing of a proceeding is one thing.
yes.
Invalidation of land acquisition proceeding is another. ಅಲ್ಲಿ ಲ್ಯಾಪ್ಸ್ ಎನಾಕ್ಟ್ ಆಗಿರ್ಲಿಕ್ಕಿಲ್ಲ. ಅನೇಕ ಕಡೆ ಲ್ಯಾಪ್ಸಿಂಗ್ ಎನಾಕ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ. ಬಟ್ ಇನ್ವ್ಯಾಲಿಡೇಷನ್ ಇತ್ತು ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಸ್ಟ್ರಕ್ ಡೌನ್ ಬೈ ದ ಕೋರ್ಟ್ಸ್.
Yes, I bow down, I bow down to that, my lords. But my humble submission is only this. Because now one has to reconcile Delhi Airtech 3-judge bench ruling with Constitution bench ruling in Indore development.
No. No question of we reconciling.
Because,
This judgment, how later judgment interprets a particular judgment,
yes,
that becomes to say, to give an
yes, I bow down, I bow down.
extreme example of Upendra Bakshi.
Yes,
Dr. Upendra Bakshi said, if Keshavananda is interpreted by a learned single judge of this court, he did not use the word learned, maybe nobody is learned in his view. He said, if one single judge of the High Court interprets Keshavananda, it becomes the law.
Correct.
Another judge cannot say,
yes,
this is wrong. At the most he can say,
yes.
let it.
My
go
lord,
to-
I will rephrase my
that-
words.
that-
Not to reconcile, but our humble submission is the ratio of Delhi Airtech is only that these two twin requirements have to be satisfied. Now come to para 8, my lords. Para 8 allu, they
Sir,
put,
you agree that 80% has to be paid.
yes,
And if it is not paid, it will not invalidate the proceeding, but he will be entitled to interest. Is your
he will be entitled to interest.
interest.
And if we do not pass award within 2 years,
Then lapse.
lapse. But under no circumstances, if just because we have not paid 80% with the, as per
And
17,
acquisition will not lapse.
no. And last portion also kindly see, my lords, para number 17, para 17,
So ಹಿಂಗ್ ಹೇಳು. Acquisition will not lapse. In
Yes.
other words, 11, because they have not made or tendered payment of 80%.
Yes.
11A does not become invocable by that one.
yes, yes,
It's only lapse of time.
yes, yes.
But if they do not pay, tender or pay, except in other circumstances, whether acquisition proceeding will lapse or not, your answer is, it will not.
It will not, it will not.
Learned counsel
And in
repeat
any event, Delhi Airtech is not an authority for that
for that
proposition.
proposition. Okay. Learned panel counsel adds that the Delhi Airtech is not an authority for the proposition that violation of 17(3)(a) would result into invalidation of acquisition proceedings. That's your proposition.
Yes, my lords.
Okay.
And my lords, I further rely upon para 12, where they have said, so far so good. The question, however, is as to whether the rigor of section 11A of the Act 1894 will apply when the appropriate government exercises its special power in cases of urgency, which does not contemplate the same procedure as in the normal acquisition process noted above. And then, my lords, para 17, your learned senior counsel had read that if in the case concerned the mandatory prerequisite is not complied, such acquisition will lose its character as